the rule and the post facto, if at all, a very rare exception.
And not to be done in a blanket manner. Now, my lords, our concern comes that these notifications, they are like a many-headed hydra. One head gets cut off, one window expires, a new head emerges. So our request would be, in the interest of the environment, let there be one line drawn, but no further, because it will be very unfortunate, my lords, if 20 years hence we are in this. That is the sum and substance, my lords, of what I. And yes. Yes.
Suggestion from your side.
And
We appreciate that part.
I'm grateful, my lords, for such a patient hearing. I was a little bit frightened, my lords, but I'm very grateful.
You are better prepared than as compared to many senior lawyers. And your presentation is also far, far better.
Thanks, ma'am.
Your understanding of environmental law is also very good. We appreciate that.
Deeply obliged. My
Yes,
learned.
Madam Aishwarya.
Yes.
Only two submissions. I appear in that.
Don't spoil what she has argued now.
Very well. No, only one part I just wanted to point out. It's
please.
only as a matter of fact. As far as the exception and the rule in that context, there was actually an attempt, there was a draft which was issued in 2020, where the ministry tried to even amend the 14/9/2006, trying to bring the ex post facto clearance as a part of the main regime itself. That was the draft stage. The comments were being invited, and ultimately the ministry gave up. The only, even in Fatima's case, Manas, which is the Madras High Court case, and the Madras High Court did protect them. The question still remains is, if the ministry's case is this, that this is a one-time exception rule, then there is no difficulty there should not be any difficulty on this side. The second part, my lords, what the ex post facto perhaps also needs to be seen, and whenever your lordship are going to hear the ministry is, it's not just about the project proponent not being aware. There are authorities like the pollution control boards, which issue the consent to establish and consent to operate. Now, any activity, such as a building of a hospital or any major activity, when it happens, if the proponents have even not cared to go to the pollution control board, or the pollution control board over neglecting the fact that such a project required an environment clearance, yet issued a consent to establish, because any major activity cannot be established without a CTE certificate. Even after environment clearance is being granted, the project proponent has to go to a pollution control board, say that I have an environment clearance, I have other necessary approvals. So only that aspect even the ministry may clarify, because the SOP seems to be silent on that. What about the pollution control board angle?
My lords, I appear for the union, my lords, the ministry that has issued, my lords. And I want to, my lords, first start by, my lords, showing to your lordships the conclusions of the judgment that has been reviewed. My lords, the judgment that is referred to as JUR, my lords, the judgment under review in the review order, my lords, held that the 2017 and 21 notifications were bad. Restrained the union government from issuing any such notifications in future. But, my lords, interestingly protected all the clear ECs that had been granted both under the 2017 notification as also the 2021 notification. My lords, so while the judgment under review as it then was and has been recalled, while, my lords, it restrained the union government for all future times to come, my lords, but specifically protected all that had been granted. Proportionality was applied in a manner in that judgment also, my lords. Now, the judgment of the my lords, of the review that your lordships have seen, my lords, at length, there are 2 or 3 aspects in that judgment, my lords, that I do want to highlight. But before doing that, I want to show to your lordships the SOP once more, my lords. Kindly have the SOP that is under challenge, the OM, which issues the SOP 2021, because 17 was a one-time window. That is actually, that window closed long back, my lords. And it's 2021, which lays down the regime, which your lordships may look at it, because the understanding that we have is that it is not an ex post facto clearance mechanism at all. Our understanding is, and that is the intention with which we have come with this OM, my lords, is to bring everyone who is operating out of the EIA regime away from the rigors of EC conditions. They should be identified. They should be scrutinized by expert appraisal committees. And then two bifurcations are made. One, activity which is impermissible as on the date the activity started. And I will show to your lordships, it includes, it categorically explains by way of an example that suppose an activity happens at a CRZ1 zone. So CRZ1 zone is a prohibited activity. Citus was one submission, my young colleague, Mala's very eminent young colleague, the way she placed her case before your lordships, Malats. On environmental jurisprudence, we cannot quarrel with her at all, Malats. And it is our respectful submission that this OM is in accordance with that, in progression of that environmental jurisprudence rather than being regressive. So when it bifurcates, so the example that it gives is if the activity is falling at a CRZ1 zone, then it is impermissible activity from day one. It has no option but to be closed, demolished, and environmental penalties to be levied. The second silo is, if it is a permissible activity, first it has to close. If it is a case of expansion, then it has to go back, roll back to the permissible limit that it was on. Then assessment by the expert appraisal committee to see what are the conditions. And then again, this second silo divides into three bifurcations, my lords. One is a remediation plan for the pollution that they have committed. Second is a penalty for the environmental harm that they have committed so far. Third is a future EC. This OM does not contemplate ex post facto environmental clearance in any manner. And may I attempt to show that from the OM itself? If your lordships will kindly have the OM with me for a moment, my lords, I will highlight just few aspects of the OM from our understanding of and our intention of the OM. Oh, thank you, sir. My lords, the copies my senior colleague is carrying, otherwise just the OM your lordships will kindly have. Otherwise,
17.
2021. My lords, 17 OM was a 6 months period. That was a notification which was valid only for 6 months, and that has actually, it has run its course, my lords. So your lordships have the 2021 OM, my lords. This is the nub of the challenge. So, my lords, the OM first notes the law as propounded, my lords, by your lordships code, by the NGT. Para 4 is significant of this, my lords, because para 4 is a judgment of NGT, Tanaji, where, my lords, we were directed, and I will read one paragraph of Tanaji, my lords, where the NGT noted that there was no regime existing, and therefore cases like this were coming straight to the courts of law, my lords, and they had to be dealt with. So the direction was for MOEF, which is noted in para 4, that a proper SOP be laid down for grant of EC in such cases so as to address the gaps in binding law and practice while currently being followed. The MOF may also consider circulating SOP to all CRs in the country. So, my lords, the law is noted. Para 5 notes, my lords, the principles of polluter pays, principles of proportionality. Other judgments are noted. And then kindly see from para 8, my lords, at where the legal provisions, internal page 4 of this SOP. I'm not troubling your lordships with the principles of environmental jurisprudence on which we as the union cannot have, and we do not have any, my lords, any recommendation for dilution of the environmental jurisprudence. My lords, kindly,
Basically, it's a compilation of a small mini handbook of the environmental principles and the statutory regime, and then the policy regime guiding principle para 10.
yes, my lords.
And then how to deal with the
Please, my lords.
cases of violation.
Yes, my lords. And kindly see the principles, how all of these principles are included, including the principle of no ex post facto EC. So, my lords, what I want to highlight is your lordships will kindly see from para 10. May I place from para 10? Internal page 5 of the OM, my lords.
SOP guiding principle.
Yes, my lords. Without prejudice to any other consequences, action has to be initiated under Section 15, read with Section 19 of the Environment Protection Act against all violations. So first thing is the three silos I was saying after, my lords, that action has to be initiated. Projects not allowable, permissible for grant of EC as per extant regulations to be demolished. So whatever is not permissible, it has to be demolished. Projects allowable, permissible if prior EC had been taken as per extant regulations to be closed until EC is granted if no prior EC had been taken, or to revert to the permitted production level in case prior EC has been granted. So, my lords, we are treating as violation cases even those where they have expanded the production, or, my lords, the capacity, etc. And they had a EC for an earlier production level. Polluter pays, violators to pay for violation period proportionate to the scale of the project and extent of commercial transaction. Setting up mechanism for reporting of violation to the regulating bodies. Then, my lords, para 11 deals with SOP for dealing with violation cases. First is closure or revision. So first step is, if no prior EC is taken, order to close its operation. If prior EC is available for an existing old unit, order to revert the activity to the production of permissible units. If prior EC is not required for earlier production level but is now required, my lords, many of the cases were such that activities are added subsequently, and the unit had been operating from before. But when activity is added, we make it mandatory for even existing units to take EC. So then they are also treated.
Even if it was not required or obligatory
Please,
at
my
the
lords.
time of setting up of the unit,
Yes, my lords.
but subsequent change in law
Lordships.
brings it within the purview of law,
Please, my lords.
then in that case also they were required.
I'm grateful. So the third example is those categories, my lords, because in environmental jurisprudence, we don't.
So it is not compromising with the environmental principle, it is expanding the environmental principle.
I'm very grateful, my lords. My intention is to show to your lordships that what has weighed with the union government in bringing this. And, my lords, if your lordships feel that something more is required to be done, we are here, my lords. There is no shying away from anything more to be done to protect the environment. But the aspect that I'm highlighting is, how is this ex post facto, my lords? Because I'll give you lordships an example. Formaldehyde units, coal tar units, they were added in environmental regulation to obtain prior EC later on. But, my lords, unlike criminal law, environmental jurisprudence does not allow earlier units to operate without. So they also have to take EC with.
Jurisprudence does not bail out them.
I'm
That
grateful.
you like a criminal prosecution, you can't say that it was not an offense and therefore.
Please, my lords. So they have to fall into the regime. So that is the third example. So please see, first step is this. Either you close down or you go back to the previous regime or restrict the activity. The second step is action under the Environment Protection Act. This is penal action, my lords. Whatever is the violation that has happened, so the first step is close or revert back. Second step is action against the Environment Protection Act. The third is, my lords, appraisal under the EIA notification. And this I want to read: the permissibility of project shall be examined from the perspective of whether such activity project was at all eligible for the grant of prior EC. And then it divides into two silos. A, if not permissible, the project shall be ordered for demolition closure after issuing show cause notice and providing an opportunity of hearing. And please see this example. If a red industry is functioning in CRZ1 area, which means that activity was in the first place not permissible at the time of commencement of project, therefore the activity is not permissible and therefore shall be closed and demolished. That example makes it clear, my lords, that if it was initially not permissible, it will not be taken as permissible. Then respective regulatory authorities shall issue directions under Section 5 for closure and demolition. Then second silo, if permissible, as per extant regulation at the time of scoping, if it is viewed that the project activity is otherwise permissible, terms of reference shall be issued with direction to complete the impact assessment studies and submit environmental impact assessment report and environmental management plan in a time-bound manner. My lords, this is now an additional silo. This is after the first step of closure and the second step of having, my lords, paid under the penalty for the violation. In the third step, the second silo, now 3 more, my lords, please see Roman 2. Such cases of violation shall be subject to 3 things: damage assessment, remedial plan, and community augmentation plan by the central level sectoral expert appraisal committee or the state UT level expert appraisal committees, as the case may be. The competent authority shall issue directions to the project proponent under Section 5 on case-to-case basis, mandating payment of such amount as may be determined on polluter pays principle and undertaking activities relating to remedial plan and community augmentation plan to restore environmental damage caused, including its social aspects. Upon submission of EIA and EMP reports, project shall be appraised by the Central Sectoral Expert Appraisal Committee of the state or the center, as the case may be, as if it was a new proposal. If on examination of EIA EMP report, the project is considered permissible for operation as per extant regulation, the requisite EC shall be issued, which shall be effective from the date of issue. No regularizing past violations. It is from the date of issue. There's nothing ex post facto, nothing goes back. However, during appraisal after examination, if it is found that even though project may be permissible, but not environmentally sustainable in its present form, configurations, features, then the project shall be directed to be modified so that the project would be environmentally sustainable.
This is where the post facto character comes in, that it does not include when it is not sustainable, the project will be directed to be closed or modified. It
Please.
only modifies it.
Please, my lords. My lords, this modification is only if it is permissible but not environmentally sustainable in the present form. My lords, please see, this is a step after step 4, where step 4 EIA and EMP reports, if they find it to be not in accordance, it will be closed down, my lords. The idea is not to have a kind of dilution for any projects or activities. If the project or activity is polluting, then it will be closed down. Only if it is found to be permissible but not environmentally be sustainable in the present form. And my lords, if on a case-to-case basis, this exercise is found to be erroneous, arbitrary, or extraneous features, my lords, your lordships will look at it.
6 takes care of it.
What I'm respectfully submitting is, and then please see 6. If, however, it is not considered appropriate to issue EC, the project shall be directed to be demolished, closed. If such project proposal is a case of expansion, project shall be directed to revert back to the extent of activity. Well, so even if it is permissible, this power is retained with the EIA, EMP expert appraisal committees to say whether it is to be continued or not, my lords. Then please see, Center Sectoral Expert Appraisal Committee or the state so-and-so, as the case may be, may insist upon public hearing to be conducted for such categories of projects in which the EIA notification so-and-so requires public hearing. The project proponent shall be required to submit a bank guarantee equivalent to the amount of remediation plan, natural and community resource augmentation plan with the Central State Pollution Control Boards. Qualification of such liability shall be recommended by the appraisal committee and finalized by regulatory authority. Bank guarantee shall be released only after successful implementation of remediation plan and natural community resource augmentation plan. The activities as above clauses shall be undertaken simultaneously wherever feasible. Environmental clearance, if granted to such project or activities after due appraisal of EIA, EMP reports, shall be effective only from the date of issuance of such clearance and shall be subject to compliance of obligations towards damage assessment, remedial plan, and community augmentation plan, etc., finalized. Then penalty provisions for violation cases. This is, my lords, laid down that for new projects, this is the percentage of penalty that will be levied. So this is penalty, my lords. This is also stipulated. This is all in addition to the remediation plan, in addition to the environmental protection penalties, EP penalties, in addition to the augmentation plans. Then, my lords, para 12.1, your lordships will see over the page. Without prejudice to the obligations as per A and B above, where project or activity is considered for appraisal as above and project proponent fails.
Before that above,
Yes, my lords.
for expansion projects.
Yes, so the penalty is laid down for,
If I recollect correctly,
my lords.
the expansion concept of expansion was there, permissibility for expansion was there in the original notification of 2006 also.
My lords, for example, there's an electricity plant which is operating at say 50 megawatts, my lords, and it needs to expand to 100 megawatt. It needs to take a fresh EC.
The originals, in the first notification of the first scheme came in 2006.
Please, my lords.
Even that also, Madam Srishti, probably that talks of expansion.
Yes, my lords.
And you need,
Because there are very rigorous conditions.
Yes,
So will have to be, one has to sail through those,
Yes.
then only it is done.
Please, my lords. So for expansion, a fresh regime has to be done, my lords. So that is why this identifies as two, my lords, for new projects and for expansion projects, because even if you're expanding without EC to a limit that is above, then you are treated as a violation case. My lords, I was placing 12.1. Without prejudice to obligation as per A and B, where project or activity is considered for appraisal as above and project proponent fails to provide required information or requisite documents or complete requisite study for the purpose of EIA EMP reports, does not furnish any reports so and so, without reasonable cause, it shall be inferred that project proponent is not serious enough and the project or activity shall be directed to be demolished or closed. Then percentage is halved if they are coming on their own. Suo motu, the penalty is halved. Then penalty, please see 12.3. Penalty as above shall be in addition to the liability for carrying out various remedial measures which will be worked out based on the damage assessment for quantifying environmental damage caused due to unauthorized project activity as per step 3 enumerated. Then identification of violation cases, Malats, this para 13 deals with that it lays a direction for all environmental protection, the pollution control units, etc., to go out actively and look at all and bring all of them. So, Malats, my respectful submission is, the whole idea here is to bring activities that are operating out of the environmental impact assessment regime, to bring them into the regime, to assess the damage that they have done, make them pay for that damage, make them pay for the remediation from their activities, then lay down conditions. First, appraise them, whether it is permissible. If it is permissible, again, whether sustainable in the current form, whether not sustainable, closed. If it is not sustainable in current form, then it has to be changed. All these bottlenecks and yardsticks having been laid down, my lords, in my respectful submission, my lords, and please see the data. Your lordships will see the data. I am carrying data, my lords. Lordships will permit me to place written submissions. I'll file in that. Para 105 of the judgment, my lords, Justice Gawai's judgment portion, my lords. We had given the list of projects there also. My lords, the government projects alone, for central government projects, there are projects to the tune of 8,293 crores. For state projects, there are 11,168 crores. My lords, today as a nation.
Understand the public utility of these projects, but we don't understand non-adherence to law by state and the central governments. The state and the central governments certainly cannot argue that they were unaware of environment clearance. It is a different thing where if a particular activity subsequent to its being undertaken comes within the fold of EC.
Please,
but if they were within the fold of EC, a central government or a state government,
yes, my lords,
is supposed to be the repository of the rule of law.
yes, my lords.
That agency itself violates.
I cannot, my lords, justify that in any way, my lords, but your lordships are
We
today.
understand the equity of public utilities.
Please, my lords.
Absolutely.
So, my lords, that I can't really today justify, my lords, new projects that have started, but your lordships have seen that the violations.
But what actually is falling from the petitioners, not a serious challenge to permitting the projects if they are compliant. But they are saying that the way in which the regime is being created,
Yes, my lord.
it really amounts to a complete liquidation of the requirement to adhere to environment regulations, prior consent, etc., and allow everything to go on till it is again closed.
My lords,
And you know that governmental actions in implementation, when laws are made, they are made uniformly,
yes, my
but laws are not applied uniformly. So when it happens that the OM says it will be closed, it will only be closed when you implement that OM. So effectively, the cleansing effect that you want to make will not really give any significant difference to the impact on environment.
my lords, my submission,
Concern.
I bow down, my
Not
lords,
saying
but
that we accept that proposition, but that is the concern which is being said.
my
That
lords,
the structure of the law makes it rigid
yes, my
in
lord.
order to ensure its implementation.
My lords, may I say this, my lord?
Because what
Here,
will
one
happen?
line concern is that exceptions should not become.
Yes, exceptions
That-
should not become.
that's the only-
Yes.
My lords, may
What
I
happens
submit?
is, just consider this.
Yes, my lord.
If we say prior consent is non-negotiable,
Yes, my
then anything done without prior consent, you are duty bound to stop.
yes, my-
If OM regime comes in, then everything is permissible till you implement the OM and close it.
my lords, may I endeavor to put it a little differently?
We are carrying on.
My lords,
Oh, sorry, we will stop it and then we will go
my
forward.
lords, may I endeavor to put it a little differently? Your lordships will see that the first step in this OM is closure.
That is what we are saying. Law,
Yes, my lords.
in the classical scheme that you have made is correct. You are absolutely right. You bring down the illegal perpetrators.
Yes,
But the question is, when it comes to this sort of an
Implementation.
OM,
Yes, my
it allows the perpetration of activities without prior sanction, awaiting your intervention through the OM.
My lords, may I,
Whereas if the OM is not there, but the 2006 notification is there, it is a complete roadblock to anything without a prior sanction.
my lords, but this may not be entirely, my lords, in the manner that petitioners are projecting, because this makes it more expensive, more difficult, more onerous on them in every which way. The remediation, the penalties, minimum penalties that are earmarked, my lords, it is not like anyone who has violated the EIA regime.
Comparison, although we have not examined whether that would be a good comparison, building laws in municipality.
Yes,
Every municipal law
Yes, my lord.
speaks of a prior sanction for buildings.
Yes.
Now, if we interpret prior sanction for building to be post facto sanction, then that will actually give a great fillip to rampant illegal constructions. And then whenever a notice is given for demolition, they will say, as per extant rule, we were entitled to one floor. So please allow us to preserve that. This is the situation.
Lords, I see that concern also, my lords.
We have fully, you have really brought out the essence that this is not in effect because we are stopping and then reviewing.
Please, my lord.
The concern which is expressed is the essence of imperativeness.
Please, my lords. My lords, like I said, my lords, the union government is, my lords,
How much, many minutes more?
my lords, I can conclude in 5-10 minutes, my lords.
No, we'll give you 10 minutes more and 5 minutes each, another 10 minutes.
Please,
So
my lords.
20 minutes on Monday. What Monday means?
Wednesday, my lords. First working day.
Not on first.
After the holiday.
Yes, my lords, that would be Wednesday. Monday, Tuesday is not working day.
On sixth, huh?
For us, Monday will be Wednesday, my lords.
15 to 20 minutes will.
Lords,
Kind of rest you can give a brief note.
I'm grateful.
Wednesday, that's first. Sixth, Monday, first Monday. is-
Single, Mr. Lokesh, your chief secretary has the guts not even enter an appearance. Huh?
I just called him, my lord, because.
What do
I
they
came
think of
about
themselves?
this order. In fact, my lord, there is some miscommunication. My lord.
So you are compelling us to take some harsh view in every matter.
extremely sorry, my lord, there was some miscommunication, my lord, I couldn't get the, instruction, my lord.
The most unrepresented, most casual approach and most poor assistance to the court is coming from your state. And thanks to your bureaucracy. Warn him, comply within a week, otherwise we will take it very seriously. Every time you take us granted. First take a chance on 6th. We might take up your matter if not on 6th, then on 10th. So, but be ready on 10th.
Since I may be in difficulty, my lords.
Please,
I may be in difficulty on 10th, my lords. I have,
on 10th. No, please, you will make it.
my lords, that's that judges inquiry committee, my lords.
Oh, okay. What time you will be required?
My lords, it goes on.
All day.
All day, my lords, till night it goes on, my lords.
Then, in any case, you will, we will give you 5 to 10 minutes.
I'm
on
grateful, my
6th,
lords. I'm grateful,
and we'll see then what is.
grateful.
Taking for 5 minutes, 10 minutes, state of Tamil Nadu. State of Tamil Nadu was 5 to 10 minutes long because all our projects are.
On this matter,
Yes, please.
in this very matter,
Not in
we
fact,
will,
Madras-
we'll give you 5 minutes.
Madras-
We understand your problem.
Lord, we have, Lord, also filed a appeal, Lord, against the Madras High Court, because I see none of the, Lord,
Rest of
Madras High
the,
Court order.
rest of all of you, the union will explain. Rest of all of you can very well argue. Your argument is very simple, that your problem is because of the courts.
Lords, can I just make an urgent request, my lord? Can I just make an urgent mention if my lord would permit just 10 seconds? Just 10 seconds, if my lord. Just an urgent request, my lord. On 18th February, my lords were pleased to direct release of 125 crores in my favor, my lord. I moved a letter before the registry. The MA is registered. The financial year is changing on 31st March, my lord. Now, if I get it in the next year, my lord, the tax liabilities will come in. So therefore, a procedural order of the MA to be allowed where all the details have been given is required to be passed. The reason is because 31st March, the financial year will change, my lord.
So then what should we do?
My lord, at least
Pass-
it has been passed by my lords, my lord, on 18th February, and within 2 days I gave the letter, my lord.
We can't pass an order that before 31st March it should be paid. You don't know, if there is non-compliance, you know, you.
No, my lord, the compliance is there. I'm not putting allegations anyone, my lord. I must make it very clear. All that I'm saying is, my lord, the MA is showing for 15th April. Now, if the money, very well.
My lords.